Good morning, and thanks to all of you for joining us for this morning's session, Coffee and Conversation with Legislators. We will be recording this morning's session to share out with our community and our networks. And really here, the goal is that the MSBA is focused on connecting legislators with our members, not only now during the session, but throughout the year. And we have had a great time connecting with many of you throughout the year. We saw some of you at our lobby day in January that was virtual. And we have a lot of sections that are hard at work, focusing on legislation that's impacting our members and all of our communities. So today is really extending that connection, and it's the start of a series that we have where we will be having conversations with legislators and Maryland leaders as well. So we're excited to welcome Chairman Will Smith, who is representing Montgomery County in the Senate, and he also serves as chair of the Judicial Proceedings Committee. And he's been a really tireless leader during this time, especially throughout the pandemic, and a wonderful partner to the MSBA and the Access to Justice community. So he'll be joined today in conversation with former Senator Bobby Zirkin, and he also has a long history as a legislator. So we would ask everyone during the session, if you could please mute yourself, but feel free to post any questions or comments in the chat. And I will turn it over to Bobby. Thank you.
All right, thank you so much, and good morning, everyone. It's a pleasure to be here, and it's an honor to be able to do this conversation with my former vice chair and current chair of JPR and very good friend, Will Smith. So I'm going to give a quick introduction as to who Will is, and then we're going to turn it over for a conversation about some of the bills that are still hanging around in the General Assembly and where we are, and maybe talk a little bit about how attorneys and MSBA can become even more active in the legislative process, and we'll see where the conversation goes. So Will, for those who have not had a chance to meet him, obviously, as you know, is the current chair of JPR. He was elected to the House he was in the House of Delegates from 2015 to 2016, so a very brief stint in the House of Delegates, and then came to the Senate, I believe, in 2016, correct, Will? All right. He is currently the chair of JPR, which, for those who don't know, there are 4 standing committees in the Senate that deal with a different subject matter. And Judicial Proceedings deals with all matter of criminal law, criminal procedure, civil law, civil procedure, family law, estates and trusts, corporate law, real estate, just a wide range of legal issues. Will also serves on the Joint Committee on AELR, which is for Administrative, Executive, and Legislative Review, or all of the executive branch administrative actions. He's on the Legislative Policy Committee, the Joint COVID-19 Legislative Work Group, the Rules Committee, a number of caucuses, including chair of the Maryland Veterans Caucus, and is also a member of a number of ad hoc commissions, including the Juvenile Justice Reform Council, the Maryland Military Installation Council. There's a whole list of things. This is a very busy man. Will was born in Silver Spring, attended the Barry School, the College of William and Mary. He was an AmeriCorps graduate. He earned a master's at Johns Hopkins and his JD at the College of William and Mary as well. He was a national intelligence officer and with the U.S. Navy Reserve. And some of you may know when he was my vice chair, he decided that he had had enough of me and left to go to Afghanistan to go serve. He was attached to the 1st Armored Division in Afghanistan with the U.S. Navy Reserve. His resume goes on and on and on. He's an impressive and incredible young man who is doing great things for the state. And so, Will, thanks for being with us, and maybe you could, tell us a little bit about yourself, and let's start by maybe talking a little bit about how you got into office in the first place.
Sure. First, I would say good morning, everyone, and thank you for having me. It's a pleasure and an honor to be here, Mr. President. And I see a couple judges, a couple friends of the bar, so good to see you all. And Bobby, just want to say a heartfelt thank you for all of the sage advice and wise counsel you've given me. It's been many a late night I've called you on the way back from Annapolis, sometimes in tears, but you've always given me great advice. And so I really appreciate it. And it was an honor serving with you as vice chair. And I'm glad you got out, so you look 10 years younger since you've been out. So always good to see you. First off, I'll just say that I got involved in politics when in law school. Actually, I was on the moot court team at the College of William & Mary, and we had a tournament up at WCL, the Washington College of Law at American University, and I met a constitutional law professor, Jamie Raskin. He was also my state senator from back home. And we got to talking, and he started mentoring me, sending me law review articles, and we kept in touch. And so when I came back to Maryland, I just became involved in his campaigns, wanted to just remain close with him. And so when 2 spots opened up in the House of Delegates, so in the Maryland General Assembly, we have 141 members of the House and 47 members of the Senate, 3 delegates for every 1 senator in a district. He said, "Hey, look, I'd love for you to join the team. Let's run together." And we ran together, and I was part of a team that won in 2015-16. So when he ran for Congress, then I got appointed to his spot in the Senate, and the rest is history, so to speak. So that's where I got involved in politics. But I think growing up in the Beltway in Silver Spring, you're so close to Washington, D.C. that almost everything you do has to deal or relates to politics on the national level. But as you alluded to earlier, it's really the state levels where all the action is. And that's where I'm just happy to have this continuing relationship with the MSBA, because when we get down here in the policymaking space, you have advocacy groups that are pushing one way or another, but very few experts and practitioners that give you the sanitized, just real legal advice, which is absent of bias. And I think that's something that's really missing in the policymaking process. And that, Bobby, I'm really glad we talked about this a lot, that we have an opportunity to develop and deepen those relationships with lawmakers and practitioners so that we actually make a better product on this end. We only convene for 90 days a year. We all practice in different areas, and we lack expertise in some of these nuanced areas that I think this relationship going forward can really be beneficial to the policymaking process. So I would encourage folks to get involved, come and testify, help us work on legislation, but then also the deeper our relationship and the deeper the trust, I think ultimately the better the policy will be as we move forward. So that's the best thing about this process here today, is that we get the chance to deepen our relationship.
It's great. And really important. And we'll be having conversations about that as we move forward. And we appreciate your opening yourself to all the attorneys. I think it's an important for attorneys to really deepen their involvement in the legislative process. Let me ask you this. You and I have talked a lot this year, and I found it fascinating that this obviously is a year unlike any other in terms of how you had to deal with COVID and still go down for a 90-day session with a lot of very high profile and challenging issues. Just from kind of the kind of the deep view, what how have things changed this year for the legislative process? Richard Montgomery had asked you a question about things being online. You see pictures in the paper with you guys with looks like you're in phone booths there doing the legislative process. How has it been? What has substantively changed, and have you seen any changes kind of in the way legislators have had to interact with each other?
Absolutely. I mean, obviously, we're still very much in the midst of the pandemic, and the pandemic has changed almost every aspect of our life. I mean, I know that when we're only here for 3 months, but the other 9 months practice law in DC, I've actually only been into the office twice since the pandemic. And while I'm wearing a full suit today, generally speaking, I just had what my wife calls the work mullet, where you had the shirt, the tie, but then I would be wearing shorts or boxers or sweatpants below. So things have just fundamentally changed, and things have migrated online through various platforms like Zoom or Google Meets. You know that obviously I talked to you about this marathon mediation that I had. It was all online. So things have just fundamentally changed. It's also changed the way we deal with our criminal justice system. I mean, a lot of innovative things are being done with pre-trial and pre-release that a year ago was thought to be impossible. We're still learning how that's changed, and if that's been to the detriment of public safety. The practice of law has obviously changed, and so too has the legislative process. And apart from us being in the kind of those telephone booths on the floor, surrounded by plexiglass and having to wear masks everywhere, everything has migrated online. So now everything is streamed, and to Richard's earlier question or conversation about live streaming of voting sessions and live streaming of floor sessions, gavel to gavel. While that's great, I think it's done tremendous things for transparency and people can get involved because you can sit at home and watch and stream. It's more complicated than at first blush, because now you have folks that they understand there's a show going on and that there certain things that have to be said to appeal to the base constituency back home. And I think in a sense that has been to the detriment of real tough conversation and reasoned debate. And what I mean by that is especially that's prominent in the voting sessions. So in the voting sessions, a lot of things that sound great in concept, once you get into the weeds, and you've taught me this time and again, I thought you did a particularly good job with this, is that you focus in on the merits of the law and how things actually work, and not what the kind of the tagline on the top of the bill says. And that's why, again, why having experts and people that are kind of sanitized from the bias helps, and that's what I think will help us in the policymaking process. But getting into the weeds means having some tough conversations that sometimes don't sound, and they're not packaged well for that political soundbite back home. And so there's a lack of candor and real deep debate that happens, I've noticed. And another kind of symptom of the live streaming is that social media and text messages make their way into the debate. I've actually seen this happen on the floor and unfortunately even in committee at times. And I'm guilty of this as well, because I scroll through Twitter and I see someone's making a comment on something that I've said or a vote that I've taken, and it does make you think. But the point is this: like, sometimes a tweet will come in and then someone's line of argument will change, or someone won't stand up where they would have stood up if it just wasn't live streamed. And so I think ultimately, some of those influences that make their way into this process is detrimental, because especially we have 4 standing committees and 2 policy committees. The policy committees, and this is real stuff. You can't afford to capitulate to kind of the political wins or whims of the day. You really do have to focus in on the merits, and that becomes increasingly difficult when the fast-paced politics seeps into that policymaking process. So great on access and transparency and making sure that people kind of have that schoolhouse rock rules understanding of how a bill becomes a law. Maybe not so great on the actual flavor and the tone and tenor of the debate.
Do you anticipate this continuing beyond the pandemic, or do you think that it will go back to some semblance of where it was before?
I think it'll go back to some semblance of where it was before, because obviously we'll have people, we'll have public access, so they'll have to sit in the gallery, but you'll have to travel down to Annapolis. There'll be a combination of the two, but I don't think you're going to see the level of live streaming that you have now. Because look, you'll have reporters that can make their way in, and members of the public will still be here to testify. But I think we'll probably tilt back closer to where we were before.
I know that this issue isn't necessarily a sexy one, but it's a fascinating one, and it's really important because I've heard from you and others and have seen it. In the middle of your voting session, people are tweeting at you, sometimes pretty mean things, just about things that you have said during a voting session, and it definitely has a chilling effect. I'm sure. I mean, I had to deal with a lot, not that, and that's it's a really, when you start getting into the nuts and bolts of legislative process, this was never part of Schoolhouse Rock. So it's interesting to hear this issue.
Someone's got to do a dissertation on this, how social media has changed and influences the policymaking process at the state and local level. I really think someone should do that.
Yeah, it's a tremendous, as an advocacy organization, it's important to understand what kind of other groups are doing to influence it, sometimes in very, not really particularly kind or helpful ways. You see it all the time with you guys, including going to people's houses and things of that nature. It's pretty rough. So anyway, if I could pivot, because obviously there are a lot of people on here that want to hear about, we've got you have less than 2 weeks left in the legislative session. A lot of big ticket issues are hanging in the balance. So let's start with one that's been all over the news. Obviously, the George Floyd trial is going on as we speak. one of the big, if not the big issue for your legislative session was thought to be issues about police and community relationship, accountability, LEOBR, all of those various and sundry issues. So I'm just going to open it up. Where is the General Assembly now? If you could give some ideas to what the details are of this legislation and kind of where you see this is heading.
Sure. I'll start kind of high level with the process and where we are, and then get into kind of the details of the policy. But so right now we've the Senate moved a package of 9 bills out dealing with everything from independent investigations, requiring body cameras for all police departments by a certain date, and repeal and replace of the Law Enforcement Officers Bill of Rights, which is an administrative process for discipline. So everything in between that, so 9 bills. And the House, they put forward, the Speaker had an omnibus piece of legislation that it encompassed a number of things that were in our package of 9. And so now we're in the midst of reconciling those 2 vehicles. I think they'll be ultimately broken down into 4 or 5 bills. We had a very spirited and tough debate last night. I'm here till midnight debating that. And, unfortunately that it devolved into party line politics. I think we've got some things to do this morning that I think we can fix some of that, but that's where we are with respect to kind of the process. So I suspect we'll go into a conference committee and we'll have to work the discrepancies out from both sides and hopefully have something out and done and ready for the governor's consideration before the end of session. On the merits, I think the most high profile issues deal with use of force and with the Law Enforcement Officers Bill of Rights. Those are the most high profile. I think actually the most effective and significant long range policies that are going to go into effect deal with body cameras and independent investigations, which are less kind of sexy, but I think ultimately will have a greater impact on policing and the system. But for the Law Enforcement Officers Bill of Rights, it's been on the books since 1974. It's kind of inappropriately named as a Bill of Rights. It's really just an administrative process. But I think we're all fooling ourselves if we don't realize and understand that through collective bargaining and through the political process that due process, that piece of the statute has been, I think, manipulated in a way that tilts too far in the direction of protecting officers, and that's to the detriment of I think the public interest. And I'm talking about elements of transparency for the trial process, the actual elements of due process before a chief or an executive or a sheriff can take disciplinary action. So I think that obviously the pendulum had shifted too far over in terms of the lack of transparency and ability to discipline an officer that has gone awry. So what we did was to repeal that and try to replace it with a system that was more streamlined, more transparent, and allowed for the chief or sheriff to be more accountable for those disciplinary matters. Now, to be candid with you, both, I liked what we did in the Senate, and the House did something that I think is a good product as well. But it's difficult to kind of redevelop an entire 18-page piece of the statute in the midst of a 90-day session with lots of political tension and angst, which is understandable, right? I mean, especially we are very much still in the midst of a racial reckoning and a conversation on race, and all the vestiges of racism in our country have come together and amplified in this moment. And I think that the difficult part about this entire process has been to keep a level hand and understand that there is a role for policing. This is not something that we want to, this is not a profession we want to make sure that people go into. We want to make sure that people are diverse people, talented people that want to go into public service are still involved in law enforcement and the communities they serve. But at the same time, we've got some significant reforms to make. And I think there's a very delicate balancing act to play here. And again, we talk about the politics. Groups on the left and the right will push, and it becomes very difficult and politically unpopular to make those sound decisions that further public safety, but then also allow for transparency and accountability. And I'll speak a little bit more to the specifics too. I mean, one of the high profile things was something called Anton's Law, which would have given personnel records, make them subject to discovery or under our Maryland Public Information Act, the equivalent of FOIA. These are personnel records at the current moment and therefore not subject to disclosure. No other state employee has their personnel record exposed to the public. And what we did is do that. We opened those things up, and there was a public outcry for that, because if an officer has a record of discipline or complaints and they have not been properly disciplined, we need to know that, or so goes the argument. And so that was a critical piece of accountability. But balance that with the fact that people can make anonymous and frivolous complaints against someone that can seep into the public sphere and ruin someone's reputation and career prospects and have detrimental impact on their personal lives. That's a balancing act. And I think that in the midst of this political storm that we're in, it's incumbent upon lawmakers to kind of just focus in on the merits, and that's not always politically popular.
So where, just to put a bow on that, where between the House and the Senate, there's a lot of meat on these bills. Kind of where are the big differences between the House and Senate, and I guess where do you think things are going to fall when the conference committee or whatever process this bill takes, where do you see these things? I know there were some issues about expungement of records or shielding of records. There were issues about where the independent investigations were going to be housed, whether it was prosecutors, state prosecutor, or the attorney general. Where are some of these landing?
Sure. So I'll start from where you ended off. So the offices, we had several proposals to house the power of independent investigations for officer-induced death, not kind of limited to that category, which is about 13 to 18 a year in Maryland. And so initially you had a proposal for the Office of State Prosecutor because they already do public corruption. They're chartered to do public corruption, but their office is rather lean. They have 6 or 12 people. The state prosecutor serves a 6-year term appointed by the governor. And so there are a lot of different things in play there. I thought that was an elegant solution and kind of right-sized for that task, especially if we gave them the additional resources that they need. The House did not agree with that assessment and said, hey, look, let's go with the, some to be defined independent agency that would be stood up, and or let's go with the Attorney General. And so that was basically a compromise we made to go with the Attorney General. Ultimately, for me, although I thought the Office of State Prosecutor was well suited for this responsibility, I was somewhat agnostic about it as long as there was independence, and it worked. And so the offices of the Attorney General is where I think we're headed with that. With respect to some of the other touch points, the disclosure of those personnel records is a touch point. We in the Senate had a balancing of that those exonerated or unfounded claims could be expunged within 3 years. The House did not and does not want that. And so that's likely to be removed or discussed in conference committee. Look, I think a lot of us down here, and you chief among them, have fought for the expansion of expungement within the realm of people that have actually committed crimes in the criminal law. And so although this is an administrative process, it seemed only right and ideologically consistent to allow for someone that had an unfounded or that they had been exonerated, the claim to be expunged from their personnel record, which is an administrative thing, not a criminal thing. So goes the argument. We'll see what happens with that. And then the use of force standard, in the Senate, we said necessary force, and then there are a couple other elements, but ultimately that was viewed through the lens of the reasonable officer, which is essentially what the Supreme Court has said is the standard of the day. The House went for a necessary and proportional standard, which is hard to explain and kind of talk around what is the element of the whole notion of proportionality. It's because this isn't an academic thing. This is something that plays out in real life. And so you have to kind of take into mind the actual realities of policing. And that doesn't necessarily translate well to the ivory tower assessments of what should be happening. So it's a difficult balance, but those are the 3 touch points: the use of force, MPIA, and independent investigations. We'll see where we land.
It's interesting. I hope, I know that this is getting into the weeds of one particular bill, but for those who are watching and those who might watch on a recording, I think it's important. This is just one piece of legislation out of hundreds in a 90-day session that Will and his committee have to deal with, which is, when you see how complex and complicated just one piece of legislation is. And to listen and to hear all these details, and for Will and his committee to have to figure all this out within 90 days is just extraordinary. So I think it's really good. And I think it's important for everybody to hear the complexity of these issues that are being debated down there. So that's one piece of legislation. I know some folks have asked about some others. How about there are, and you can pick and choose whatever you'd like to talk about, but this year you have tackled issues on parole reform and something called the Juvenile Restoration Act, which I know is in the same kind of in the same lane as the parole reform, and then the Walter Lomax exoneree legislation. Can you talk about those issues, in whatever order you'd like?
Sure. So I think parole reform was a big piece of my personal agenda heading into this session. And so you mentioned two pieces. One was getting the governor out of the parole process. So Maryland is one of 3 states that has, the parole commission plays a role. They recommend something and then goes to the governor's desk for consideration. The governor has a certain amount of time to take action, and then the parole commission's recommendation goes through, or they have the ability to, vote up or down on the proposal. So what that does in some sense is everyone remembers the Willie Horton style attacks, and everyone remembers how politicized that was. I think removing the governor will sanitize the state from that type of political element that's engaged in the parole process, which is is very unnecessary. It also gives that decision-making power solely to the parole commission of 10 commissioners, 8 of whom have been appointed by the current governor, who's Republican, and, oh, by the way, has the best record on record for consideration and for release of parolees of his predecessors. And I say that because I'm a Democrat. I represent Tacoma Park and Silver Spring, probably the most progressive and liberal district in the state. And the governor is a Republican. And I think that you have to give credit where credit is due in terms of the way that he's performed. But Governor O'Malley and Governor Glendening, the 2 prior Democratic governors, didn't release a single person for parole under their administrations. And Governor Glendening published, I think, a fascinating op-ed in the Washington Post speaking to the importance of removing the governor from this process. Again, I'll go back to the qualifications of the commissioners. They're highly trained. They have a rigorous process. The parole process, in terms of your first bite of consideration, and then all the criteria that you have to meet, and the goal setting that goes on within the parole commission is extremely important, not only to ensuring that the folks that are behind bars and incarcerated have an ability to rehabilitate themselves, but that they have an opportunity to arm themselves with the tools to succeed when they get out. If they get out. And so I thought that was an important element. JRA, the Juvenile Restoration Act, I think we're, 24, 25, 20, a couple states have this bill up this legislative session. So we might get up to 30 states if all goes well, in my opinion. But that essentially just gives those sentenced as juveniles an opportunity for parole. So this dates back to, it takes back to kind of the debate that you all had when repealing of the death penalty. Both of these bills kind of come back from that, or from that era where we got rid of the death penalty, but then certain people could be sentenced to life without parole. And so that was kind of a compromise that was left there. And then the governor was left in the parole process to backstop that process in terms of parole eligibility for life with the option of parole. But in the juvenile system, we are still one of the several states that still allows for juveniles to be sentenced to life without parole under the Miller v. Alabama rule, under the Miller rule, which is that it couldn't be a strict life without the possibility of parole, absent mitigating consideration of mitigating circumstances. So we still operated under the Miller regime. So we still had the kind of a constitutional standard here, according to the Supreme Court and Justice Kagan. But policy, I didn't think, and the majority of the Senate didn't think, and now the House just passed it out as well, didn't think that that was the right policy direction for our state. So you remember that 4 years after the Miller decision, there was a Montgomery versus Louisiana decision that said, look, you can apply Miller retroactively through making parole available to those that were sentenced to life without parole as juveniles. And that's exactly what we did in Maryland. And in the Senate, we said, look, you had to serve at least 20 years of your sentence, no diminution credits considered, and then you could have your first kind of parole hearing, at which point you'd be, the commissioners would look at your file, look at what happened, look at the progress you've made, set some benchmarks for the future. You'd come back in 2 or 7 years for another kind of hearing, and then you'd have an opportunity for parole. And that's essentially, I mean, that's the right, I think for me, after the research that I've done, and I think in speaking to my colleagues, this is definitely the right policy direction to ensure that those that were sentenced to life as a 15, 16, 17-year-old had an opportunity to at least have a hearing. And that's all the bill does. And I think that will make for a more just and equitable justice system here in Maryland. So proud of that legislation.
All right. And that is, those two bills are looking like they're going to both pass the House and Senate this year.
It looks like it, yeah. And I suspect that I'm not going to speculate what the governor will do.
Okay.
I don't know.
The other one that I'd asked about, which I know you and I have talked a great deal about, because to be perfectly honest, I couldn't figure it out. Although it definitely was the right policy to try to figure it out. I could never figure it out, and as much as we tried, but it seems like you were able to do it, which is good. It shows how inadequate I was. So the Walter Lomax exoneree legislation, which deals with giving folks who were wrongly convicted an ability to get compensation through the Board of Public Works. And so it was a really complicated issue based on things with the writ of actual innocence and how that works and so forth. And it seems like you have been able to figure this out. It sounds like it's on passage. Tell us about that if you could.
Sure. So the one hang up there, which it took years to kind of get to this conclusion, was the writ of actual innocence, which I think we traced this back. I don't know if we had this part of the conversation, but the drafters that put this into law actually borrowed that language from Washington, D.C. And it just didn't work in our statute. And so this was left there, lying there, and probably only getting touched in this context maybe once every other year in the General Assembly, and we just couldn't figure it out. And so you'd have to have this writ of actual innocence that have eligibility. And the way that we structured it before was then that the state's attorney, or the state's attorney in the jurisdiction where the conviction happened would then have to kind of bless off. And there are a couple of other processes where people would have to check off and approve to go to the Board of Public Works for consideration and payment. The weird conflict there was that the state's attorney would then have this weird incentive where you get to spend the state's money, and kind of their political influences that kind of seep in there. And so that created a weird conundrum that we were always uncomfortable with. And so if you were able to create a process that kind of sidestepped the requirement of this writ of actual innocence, but then also kind of limited or mitigated the role of that state's attorney that may have a vested interest, political or otherwise, in that approval process, then you were able to sidestep a little bit and create a process of state's attorney involvement, attorney general involvement, because the attorney general obviously represents the state, and still keep the Board of Public Works involved as well. You're able to kind of streamline or kind of sidestep the process. But the writ of actual innocence is still very much alive, and something that I have stayed away from so far because I don't understand it. So it'll require more study, I think, next year. But that's something that I think that after this year, I'd be really interested in engage something like that. as opposed to the parole warner.
It's interesting. A few years ago, it was almost, the writ of actual innocence was almost eliminated. It had gotten out of the House of Delegates, I think unanimously, to just do away with it. And then it got out of the Senate committee, but then ended up, the bill died on the floor. It's something worth taking a look at for sure.
Yeah.
I know you and I talked a lot about it, but it's good. So now exonerees are able to, with this new process, go to the Board of Public Works, and there's a process for getting compensation for those individuals.
That's right, and it's named after Walter Lomax, who's wrongfully convicted, spent over 20 years of his life, maybe actually more than that, incarcerated. He came down the lobby last year for the legislation before we shut down for the pandemic. He actually had a heart attack right outside of JPR. Thankfully, there was a trooper from I think from Frederick actually revived him, and he's alive and well and still advocating and pushing. And it was really special to get this piece of legislation across the finish line this year with his advocacy and support.
I saw the governor sign that already.
I suspect will happen soon, but not yet.
All right. So we have about 20, 25 minutes. There's a couple of topics still really want to talk. I mean, we could talk for hours on all these things. We've dealt with a few issues. I wanted to switch. We've done a lot of criminal. So let me, if I could
counsel,
switch.
I see. Yeah.
Yeah. We say that again.
Oh, I see. Rena, it's a right to counsel. I'm looking at, maybe that was a private message, but yeah, right to counsel. That's
sure. If you want to talk about, I was going to talk about, but if you want to start there, and then I was going to talk about civil jury prayer, just to see where things fall on that. Why don't we start with Rena's question, and then we'll move to the amount in controversy legislation.
Sure. So for right to counsel, it's a kind of a two pieces of legislation moving through. One is with the Attorney General, which would raise the filing fees for failure to pay in eviction cases. So in Maryland, to file in district court for these cases, it's $15 to file. And so what the Attorney General's bill came in and bumped it up to $120 to file. And that was because looking at some of the numbers, that you had something like 4 times the amount of filings that you did actual units on the market in Maryland. And so one contributing factor to that would be that in Maryland, we have 4 kind of rights of redemption, 4 opportunity for the tenant to redeem in any calendar year, or 3 in Maryland, and then 4 in Baltimore City. And so 85% or so of the folks that account for this filing are the same people. So people that have had kind of chronic problems for whatever contributing factors, and have been enmeshed in that process over and over again. And so the fee would raise it up to be more, to be more aligned with what our regional partners have. So we are by far the lowest in Washington, D.C., Pennsylvania, Virginia, and Delaware. And so that's the theory there. And then the money that would be captured from raising that filing fee would then be distributed to a couple of different pots of money. MLSE, there in the legislation that's before us now, there would be a pot that goes MLSE, one would go to a rental assistance fund, and then one would go to a right to counsel fund. So I think what we're going to do is we're going to have to adjust the amount that the fee goes up. And I think we're going to get rid of the rental assistance fund because we've got $800 million coming from the feds for rental assistance into Maryland, which is a short-term fix, not a long-term fix, but then put the rest of that money into right to counsel. And right to counsel would extend, the debate now is extending how far do you want to expand this right to counsel for failure to pay eviction cases in landlord-tenant, exclusively within landlord-tenant. We're not doing full-on civil get-in. That would be amazing, but not possible here. So the debate centers on whether it's just for cases in which you're facing actual eviction, or is it for anything you have an affirmative defense for. And then if you subsidize this type of right to counsel for all these cases, what impact is that going to have for the incentives for the tenant to just file litigation and keep filing because you have right to counsel? Obviously, there are income thresholds for that. But if you have a free attorney, then there is leeway there to just keep filing. And so balancing those two things is what we're trying to do here in the final kind of 10 days. But it's critically important to have right to counsel in these in these failure to pay and these eviction cases, especially we're still in the midst of a pandemic. The Access to Justice Commission that the Attorney General had this summer and in this fall, I think produced some tremendous research and policy recommendations that show that if you have access to counsel, it can have a tremendous impact on the outcome and can save us money ultimately in this state. So that's where we are with that piece of legislation. We've got a vehicle to raise some money, and we've got what expand the scope of representation.
I think your volume's down a little bit. You good?
Put the earphones in. How about now? Is that?
Yep.
There you go.
There you go. Yeah. All right.
So just the discussion broadly, we're going to expand representation. That's essentially it.
Okay. And then to move on to what I think is obviously of interest to civil litigators on both sides of the litigation is this amount in controversy jury prayer. So I know that the Senate, Senator Waldstreicher, your vice chair, had the legislation in the Senate, and delegate, I can't remember, a delegate from Anne Arundel County, Bartlett, had it in the House. Any idea where that legislation is? Can you tell people what that's about and where you think that's heading? A big piece of legislation.
Sure. So it's a big piece. I mean, it's in Maryland. So it's district court just bumping up the amount in controversy that you can stay within district court, and it requires a constitutional amendment. So you got kind of just the legislation, and then it's got to go on to the next ballot, which is in 2022, right? That's right. Then that's the next ballot initiative. So it's got to go there. Yeah. So you have two pieces of legislation, there. You know, the obviously district court is meant to be kind of the people's court. It's kind of the engine of our system where people have access, easy access. You know, you don't have to go through the whole rigmarole of juries and experts. And so that is kind of a space that if you blow out the amount of controversy, then you're going to provide for more cases to be eligible for access and play within the district court. And so that's for folks think that, you know, for access to justice person, this is something that's a critically important piece of legislation. This is not absent controversy, obviously. And so it has, I think we were close to getting it out a couple times. Maybe, I don't know if you popped it out once of committee, but we were close. And so it you know, we got it through the Senate, and it's now in the House Judiciary Committee. And I don't know what the time looks like, but I'm optimistic of the kind of the intentions, but I'm not optimistic with the clock. We've got I think, you know, under 2 weeks left, and so we'll see what happens. But I think this is the first time in a long time that the Senate has sent it over to across the House. I think it's the first time in a long time we passed it. So yeah. It's a big deal. It's a really big deal.
And it can only go into effect with a constitutional amendment. So whether it's this year or next year is kind of the same difference for the law, because it can't go in without that anyway.
That's right. So we're gonna have to wait until the voters decide in 2022 anyway. So if we got another bite at the apple next year.
Interesting. All right, we have one quick question about the Court of Appeals and Court of Special Appeals name change. Something that I resisted as chair, just because I'm more of a traditionalist. But where are we with the Court of Appeals and Court of Special Appeals name change?
You know, it's funny. You know, I was very surprised that both chambers passed it this year. And so this was never something that was on my radar screen or my top priority list. But for Chief Judge Barbera, it has been a significant policy initiative of hers. And so I've heard from her for the last several years. So this would change the name. I think, you know, New York and Maryland are the only two states in which the Supreme Court, or we don't have the Supreme Court as our highest court. So New York is actually the lowest court. It's like district court. So it's an interesting, I guess a lot of people in law school and taking the bar, law school will have an easier time, law students will have an easier time figuring out our system, but it'll change the name and it'll change, she won't be there when this goes into effect, if it goes into effect, but the chief judge will now be this, I guess, the chief judge of the Supreme Court. So we'll see how that works. But for the traditionalist in the room, I guess times are changing, and this was an initiative for the chief judge. So there you have it.
I always hated saying no to the chief judge, but I like your name, Court of Appeals. But congratulations on that piece
Thanks,
of.
I think.
And I guess with about 10 minutes or so left, I want to ask about one more bill, and then I'm going to conclude by talking about. I would like to ask you about just young. You're a young lawyer, right? I mean, or younger than me anyway, which is sad. But you are, and got into office very young, as I did. And so for the young lawyer, let's go there right now. Actually, for the young lawyers that are thinking about getting into politics, that are thinking about either running for office or, or just helping to affect change in the General Assembly. Like, what advice? Because you have a young family and you're a lawyer. You practice law full time. So, what advice would you give for MSBA lawyers, young and otherwise, that want to get involved in politics, either at either by running for office or just being involved with people like yourself?
I think, again, it goes back to where we started at the top of the hour or the top of the session, is that contact your legislators and get involved, because you have invaluable experience and expertise that can really inform and influence the policymaking process. Again, you come to this absent the kind of the biases of the advocacy community. I mean, obviously everyone advocates, but like, if you're not coming from a politically charged environment, you're just focused on the merits of the law and your experience as a practitioner, you have no idea how much of a value add that would be for us in Annapolis. So I'd say first, familiarize yourself with the legislative process as it impacts literally everything you do as a Maryland attorney, and contact your legislators, see if there's an issue or something you can get involved in. So this case is a little vignette or a case study. I'm part of the Maryland Washington Employment Lawyers Association. And so it's small bar, but they essentially have a couple of issues that they run up against every year. And they put forth a couple of ideas. One was, there's the standard for sexual harassment, severe and pervasive vice, just a single incident. That's an idea that they had. Then they wanted to raise caps for recovery for some employment discrimination claims. So they had those two ideas. We turned them into legislation, passed out of the Senate. They're now in the House. It looks like they're going to get favorable consideration there. But absent their kind of involvement and their advocacy, and then obviously their expertise for testimony and for preparation, that wouldn't happen, and those changes in the law will not happen. And so involving yourself in the process, I think can improve the legal process here in Maryland, and it will be to the great benefit of the legislators that frankly don't have time to focus. You're a generalist. You don't have time to focus in on all the details and become an expert in every piece of legislation. So your advice is much needed in Annapolis. Help us out. And as far as running for office, look, I'd say just understand that the 90-day commitment. So if you have a firm, join a firm that's forgiving, that will give you the latitude or leeway to on your billables to know that you're absent, and then know that it's a full-time job. You're here for 90 days, but the constituent services never stops. The forums, the after work events, the work on legislative initiatives in the interim, it never stops. So just understand that it's a tough balancing act. And that there are some financial considerations you've got to make, family considerations you've got to make. So it's real public service, and unless you're retired with a pension or personally wealthy, you've got to make some calculations.
How do you just to follow up on that? Look, you have an amazing wife and a beautiful child, and I mean, it's and you're an attorney, you're in the military. I mean, you have a lot of things going on. How do you, I think it's instructive for people who are thinking about running for office to hear from people like you who got in very young and are trying to balance all these things. So how do you balance all of those different considerations together as you're trying to effectuate good policy for the state?
So I think you're just understanding first, you have to be clear-eyed when you're going in that you're not going to be able to do everything. So, my class, I graduated law school almost 10 years ago, over 10 years ago now. And, those folks are now partners of law firms and have rolled into great success. I've got a couple members of my class that, frequently argue before the Supreme Court. And so you just understand that if you choose this path, then you've kind of precluded some of those other opportunities within the legal profession. You probably, will not be a partner at a large law firm if you are in the legislature. And so I think just kind of going in with just clear eyes as to where you need to channel your energy and your time. In the alternative, look, you get to make policy in the state of Maryland, and you have a real impact, and it matters. And so it's just a different avenue of service. And so I definitely wouldn't have chosen a different path. I'm glad most of the time the choice. I'm happy with the choice they made, but I think you just have to understand that there are, again, financial and time considerations. If you wanted to be a partner at a big law firm, you probably need to hold off on your political career for a little bit.
All right. So, understanding that you have a very, very busy couple of weeks and get into session pretty soon this morning, I would assume. I'm going to end this by saying, thank you so much for spending an hour with MSBA this morning. I think this has been really instructive, just talking about a few of the many bills that you've had to deal with this legislative session. It's hundreds. I think the most come through your committee, and out of any of the committees in the General Assembly, and they're all complex and they all have meaning. And so to have somebody like yourself who is, so intimately involved in the details and the complexities of these laws is really refreshing and great. So I just want to, on behalf of MSBA, before turning it back over to Shally, I just want to say thank you for spending this hour with us here today. It's been really instructive, and good luck to you for the rest of the session.
Thanks a lot. I appreciate it. It's always good to see you all.
Shally?
Thank you so much, Chairman Smith and Bobby, for this fascinating conversation. I feel like we could have gone on all morning, and we're excited that this will be the first in a series that we'll be offering. So please stay tuned for that. And with that, I hope you all have a good morning and make sure to stay connected. Thank you.
Have a good day.